Okay.
We've changed the format quite a bit. So it's just myself as well as Natalie doing this. Natalie did the sales course yesterday. When I built these, I was actually a university instructor as well. So I've done quite a few courses on security at a university level. We try to include information in the slide deck that comes from thought leaders within and outside of our industry, solution partners, and even some of our Evolve partners give the information that we have in here. So think of this as less of a seminar about ConnectWise products and more about what real security professionals actually do.
Mm-hmm.
My background is you're welcome to go ahead and connect to me on LinkedIn. But I started my career off at IBM, worked for IBM for 10 years, building up their security workforce, dealing with some of the same kind of security incidents everybody deals with today. After working for them for 10 years, I moved over to a small boutique security company called System Experts and basically did security assessments and security work for like Fortune 500 companies. So mostly bigger enterprise size companies that were out there. Once I left them, I protected the e-commerce sites for Tech Data and moved on from there to WellCare Health Plans, where I was the Chief Information Security Officer in charge of, building out and maintaining all of their HIPAA policies, plans, and programs that were out there. From there, I moved over to a company called Sienna Labs that with people that I formerly worked with at Tech Data and WellCare Health Plans. And Sienna Labs was purchased by ConnectWise back in 2018 when they wanted to bring in our security enterprise, skills to ConnectWise and our partners. And I've been doing, this kind of work ever since 2018. I don't think you have to worry about it. I don't see you as not being in the ConnectWise org. Otherwise, you wouldn't have been able to see the files or be able to download them. So I think we're good. Feel free, like I said, let me know when you need to know something and we can go into more detail on it.
Okay.
If you are looking for the MSP playbooks, it's under the resources here on the cybersecurity certifications. Some of the web pages change from time to time, but they try to keep these major links the same so it's easy to find what's out there. I do not believe these playbooks are available on the website yet. Matt Topper, who worked on the updated revised versions. I don't think he's made them available on the website yet, but I will talk to him when we have IT Nation the first week of June.
Okay.
So
trying. No?
So we changed the course structure. This used to be a monthly course. I was teaching it actually 4 hours in the morning and 4 hours in the afternoon. We changed it to be quarterly classes, so it only happens once every 3 months. Instead of it being 4 hours, it's 2 hours. And I still try to hit all the topics that we would normally hit. But what we're doing is we're trying to partner with CompTIA and having any of the content that I had in the past is going to be presented as part of some of the CompTIA classes that are available through the ISAO. So, feel free to reach out to CompTIA, and if you have any problems reaching out to them, let me know, because Wayne Salk, who used to teach these classes as well, is now working at it's GTIA, not CompTIA anymore. It's GTIA, and he has more details to be able to get us the information, or at least get us in touch with other resources. I'm going to use the community forum to be able to put some of this information out there. Obviously, I can't put the playbooks out because marketing tries to get in front of these playbooks, so I won't be putting those out here. But what I'll do is I'll put the actual PDF of this slide presentation out on the community site, and that way, if there's questions or anything that comes up after we've got off the class, we can still communicate back and forth. And I don't have a problem with you emailing me direct either.
Okay.
I usually do the where are you, but I kind of know where you're at. So, and I also know chat's working. So that was kind of my little sneaky way of making sure that chat works. Last quarter, I don't know if you were here, but in February, we went over security risk assessments. So what I can do is I can make those slides available. Just send me an email if you're interested in that.
Yep.
It was a two-way street. It was not only doing security risk assessments for you, but it was also being able to move to that next step and become a consultant for your organizations that you have for customers, and being able to provide security risk assessment services to your customers. Today is compliance, where we're talking more specifically about privacy. We'll talk a little bit in general about other compliance pieces that are out there, but I wanted to focus mostly on privacy because it's a worldwide topic, and I didn't want to go into too much into like HIPAA or other things that might be specific to the United States. One of the things that we can also talk about is PCI DSS, which becomes a problem for some folks, especially since it doesn't matter if you're the size of Amazon or if you're a small business, you still have to comply with all of the same rules, no matter if you're big or small.
Yep.
So information privacy basics. So I'm going to start off with my typical legal disclaimer. So I'm not a lawyer. I have studied some law in some of my master's classes, but my interpretation of the laws is really my interpretation, and you might hear differing views from your company's legal team. So when you need to make legal decisions for anything, you can, put my argument forward, but, chances are you're going to listen to your lawyers because they're there to, help you understand any of the legal problems that are out there, and they're going to make sure that they're covering you. So, it's better to play along as a team and make sure that everything is, in line with everything else that's going on. So also make sure you go over any of your plans with your legal team. That way you'll make sure that you're covering your company risks and providing the best assistance to your customers. I don't know if you're like me. Whenever we had legal issues, we always went back to the contracts. Sometimes the lawyers don't give you an understanding of why they put something in there. So the key is to make sure that you're following your company obligations, as well as your local territorial or country laws. So what kind of privacy concerns do your customers have? Have you had those kind of discussions with your customers?
Yeah, like they care about data they possess for their either clients or their employee as well.
Okay, that sounds fair. Everybody's got their own concerns, and depending on what the vertical is, some people, I did some work for a manufacturer of medical devices here in the United States, specifically in Minnesota, and
Yep.
their privacy concerns were all related around EPHI, which meant that not only did I have to tag a piece of EPHI, like a diagnosis code or a condition that they had, but I had to tie it specifically to the person's name, their street address, their zip code, or their name and a phone number, or the name and an account number. So there were very specific laws that we were abiding by to actually make sure that, when we took a look at the data, that was, definitely what we were looking at, protecting, or trying to figure out if it was being infiltrated and being shipped outbound. I put the yin yang symbol in here mostly because when I think of privacy and security, I think of, the contrast of yin and yang.
Absolutely.
Personally, everything that I've done security wise has been to meet the requirements of privacy. There's some things that you do in security that make sure that, you're doing configurations or you're checking to make sure that it's being patched, but it's usually privacy that drives security that's out there. So I kind of look at it to kind of focus it all together and say, hey, do you think you can have security without privacy? Well, there's a chance that, you'll use some gut instincts, but if you have specific reasons that are coming from privacy, it definitely drives your security program across. And having privacy without any security, that's an impossible thing to be doing. So let's start with, the history around privacy and privacy rules. Back in 1890, I did a bunch of research on privacy and privacy laws. And back in 1890, the U.S. Supreme Court Justices Samuel Warren and Louis Brandeis published, it was kind of like a small memo called The Right to Privacy. And it was in the Harvard Law Review. What this did was this set forth the essential definition of privacy as the right to be left alone. And both fundamental and concise, the definition underscored the personal and social dimensions of the concept that would linger long after that publication was published, of that landmark essay. So in the time since, numerous individuals, organizations, and world bodies have, poised their own privacy definitions that were out there. Privacy has been defined variously in the desire of the people to choose freely the circumstances and the degree to which the individual will expose his attitude and behavior to others. So it has been connected to the human personality and used as a mean to protect the individual's independence, their dignity, as well as their integrity. Privacy has been reduced to the elements of secrecy, anonymity, as well as solitude, which themselves may be lost due to personal choice or state or even third-party actions. So more recently, privacy was defined by the United Kingdom's Calcutt Committee back in 1997. And I pulled the definition out. Basically what it says is the right of an individual to be protected against intrusion into his own personal life or affairs, or those of his family by direct physical means or by publication of information. The Australian Privacy Charter states, a free and democratic society requires respect for the autonomy of individuals and limits on the power of both state and private organizations to intrude on that autonomy. So establishing an understanding of how privacy is defined and categorized is, as well as how it has emerged as, social concern, are critical components to understanding data protection as well as privacy laws as they've been established today in, throughout the world. All right. We've defined classes of information here. So while privacy can be defined in many different terms, it's equally important to understand how it's categorized. There are four main areas of privacy that are of particular interest with regard to data protection and privacy laws and practices. We'll start with the first one being information privacy. So information privacy is concerned with establishing rules that govern the collection and handling of personal information. This can include credit card information, medical data, as well as government records. When we talk about bodily privacy, what we are doing here is we're focusing exclusively on a person's physical being, as well as any invasion of that. So such an invasion can take form as genetic testing, drug testing, even body cavity searches. When we start talking about territorial privacy, what that concerns is with placing limitations on the ability of one to intrude into another individual's environment. Environment is not limited to the home. It may be defined as a workplace or even a public space, and environmental considerations can be extended to an international level. So invasion into an individual's territorial privacy typically comes in the form of video surveillance, identification checks, and the use of similar technologies and procedures. The fourth privacy element that we have here is communication privacy. And what this does is this encompasses protection of, means of correspondence. This includes postal mail, telephone conversations, electronic mails, as well as other forms of communicative behavior, as well as apparatus. So while some of these categories may be interrelated, what we're going to do is we're going to focus exclusively on the legal, technological, operational, and practical components of information privacy itself. So let's dig a little deeper into the social origins. The concept of privacy as a social concept is rooted in some of the older texts and cultures known to man. Privacy is recognized in the Quran and in the sayings of Muhammad, where there is a discussion of the privacy of prayer, as well as in the avoidance of spying or taking ill of someone behind their back. Privacy is also referenced numerous times in the Bible and in the laws of classic Greece. So the concept of the freedom from being watched has historically been recognized by Jewish law. Lastly, privacy protections were incorporated into the cultural fabric of ancient China. In addition to being intertwined with religion and culture, privacy has arisen within the context of human rights itself. In December 1948, the General Assembly of the United Nations adopted and proclaimed that there were universal declarations of human rights. This declaration formally advanced the notion that, and this is the quote out of it, it says, "No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence." The statement was intended to encompass a wide range of content, and it's evidenced by Article 12 of the Declaration, which describes both the territorial and the communication notions of privacy. Also back in 1948, the Organization of American States, or OAS, adopted the American Declarations of the Rights and Duties of Man. The declaration predated the Universal Declaration of Human Rights by 6 months and conveyed a similar sentiment providing that every person has the right to the protection of the law against abusive attacks upon his private as well as his family life. In 1950, the Council of Europe set forth the European Convention for the Protection of Human Rights and Fundamental Freedoms. The convention acknowledged the goals of the affirmation Universal Declaration of Human Rights and sought to secure the recognition and observation of the rights enunciated by the United Nations. The convention provides that everybody has the right to respect for his private and family life, his home, and his correspondence. Article 8 of the treaty limits a public authority's interference with an individual's right to privacy, but allows for an exception with regard to the interference that is in accord with the law and necessary to preserve a democratic society. The legal protection of privacy rights has a similarly far-reaching history. It actually began in Europe in the mid-14th century, and the Justices of Peace Act, that was in England in 1361. This act included provisions calling for the arrest of peeping toms and eavesdroppers. In 1765, British Lord Camden struck down a warrant to enter and seize papers from a home, and in doing so, he wrote, and this is a quote, "We can safely say there is no law in the country to justify the defendants in what they have done. If there was, it would destroy all the comforts of society, for papers are often the dearest property of any man can have." So, what he was really looking at is making sure that, people understood that there were private things that were inside your house and that those pieces should be, protected. I also saw one that parliamentarian William Pitt shared his views of writing. His quote is, "The poorest man may in his cottage bid defiance to all of the force of the crown. It may be frail, and a roof may shake, the wind may blow through it, the storms may enter, the rain may enter, but the King of England cannot enter. All his forces dare not cross the threshold of the ruined tenement." So, in ensuing centuries, other European countries advanced more particularized privacy protections. The Swedish Parliament enacted Access to Public Records Act in 1776, requiring the information held by the government to be used only for legitimate purposes. In 1858, France prohibited the publication of private facts, with violators of the prohibition subject to strict fines. The Norwegian Criminal Code prohibited publication of information that relates to an individual's person or domestic affairs, and that was as early as 1889. Our contemporary concept of information privacy has its roots from the 1960s, and this was with the advent of information technology. Computer hardware and software systems that handle data processing and storage within businesses, governments, and educational institutions. The increased use of IT systems in the modern age for these purposes of managing and conveying data, including personal information, spurred an acute interest in privacy practices and the privacy rights of individuals. Demands for formal rules governing the collection and handling of this personal information grew as powerful new computer systems and increased surveillance potentially were developed. The first response to the concern can be traced back to Europe, where the German state enacted the first known modern data protection law, and that was back in 1970. This German law was motivated in part by the growing potential of IT systems, as well as an attempt to prevent the reoccurrence of the personal information abuses that characterized the end of the Third Reich and post-World War II Germany. So such concerns were not confined to Germany. However, soon thereafter, several European countries enacted national privacy laws with differing objectives as well as different scopes. So it's important to note that a wide variety of data protection models have evolved over time and exist around the world today. Also, the different countries, through their social histories, have chosen to protect information by different means. Data protection varies from country to country, both in terms of the legal scheme in place and the degree to which the data protection authorities enforce the law. Some of the most common data protection models in use today include comprehensive and sectoral frameworks, as well as co-regulatory model, the self-regulatory model, as well as a technology-based model. So let's start with the comprehensive laws, which are the European Union. These laws govern the collection, use, and dissemination of personal information in the public as well as the private sectors. So generally speaking, a country that has enacted comprehensive data protection laws hosts an official or agency responsible for overseeing their enforcement. This official, most commonly, it's a data protection authority. They abbreviate DPA in most literature. This ensures compliance with the law and investigates alleged breaches of the law's provisions. In many countries, the official also bears the responsibility of educating the public on data protection matters and acts as an international liaison for these data protection issues. Enforcement and funding are two critical issues in a comprehensive data protection scheme. Data protection individuals are granted varying degrees of power from country to country. Further, countries choose to allocate varying levels of resources to the enforcement of the data protection laws. And this leaves some of the countries, inadequately funded and inadequately protected. The movement towards comprehensive privacy and data protection laws can be attributed to the combination of three major factors. So the first one is to remedy past injustices. The second one is to promote electronic commerce. And the third is to ensure consistency with pan-European laws. So a number of countries, particularly those previously subject to authoritarian regimes, are enacting comprehensive laws as a means to remedy past agency violations. Countries, particularly in Asia, are in the process of developing laws so as to assure uneasy customers, as well as, help promote and facilitate their electronic commerce. So still more countries are adopting comprehensive laws to make certain that trade between the EU and non-EU countries is unaffected by the requirements recently set forth by the EU. The data protection derivative, with the additional caveat that non-EU countries in Central and Eastern Europe are enacting laws in part to further their aspirations for really trying to join the EU. The next model we'll talk about is sectorial. And this is why we struggle here so much in the United States. But this framework protects personal information by the enactment of laws that specifically address a particular, industry sector. So, for example, different laws delineate conduct and specific, what they do is they specify the requisite level of data protection. Let's say for video rental records or consumer financial transactions, credit records, motor vehicle records, law enforcement, and we talked earlier about medical records. But sectorial laws often are used as a complement to comprehensive laws in order to provide more specific protection to the data. But there's two major drawbacks to the sectorial model that are technologically relevant and, basically the oversight. So given that the sectorial approach requires new legislation to accompany the introduction of new technologies, legislation often lags behind the technology that needs to be regulated. And also the sectoral model lacks really a central agency, kind of like a federal privacy mandate or some kind of higher level that's there to provide the oversight of the myriad of data protection laws, which can lead to overlapping regulations, creating conflict obligations. There's a plethora of compliance, requirements that are out there. We even have, there's something called the MINTS matrix that we refer back to. And what that does is that goes through and basically lists out state by state. It doesn't go down to a city level yet anymore, but it does list state by state what the privacy regulations are. And it gives information security professionals, the ability to look into some of those laws and be able to map them, across appropriately. Let's talk a little bit about the co-regulatory model that's used in Canada as well as Australia. This data protection model is a variant of the comprehensive model, which we talked about in Europe. But under a co-regulatory approach, industry develops enforcement standards for privacy and data protection, which are then enforced by the industry and overseen by a private privacy agency, such as an Information and Privacy Commission. The self-regulatory model, which is used in the United States, Japan, as well as Singapore, requires companies to abide by codes of practice as set by a company or a group of companies, as well as industry bodies that are out there, and as well as independent bodies as a mean to protect the data. Two major issues with regard to the codes of practice set by companies and industry bodies are adequacy as well as enforcement. So in many countries, industry developed codes provide limited data protection and are coupled with weak mechanisms for enforcement. As a result of this, several coalitions and independent organizations have established these codes of practice, or what they do is they call them SEAL programs. The Online Privacy Association, which is a coalition comprised of numerous online companies and trade associations, and specifically established to encourage the self-regulation of online privacy, introduced this online privacy guidelines. And under these guidelines, OPA members all come together and they agree to post a privacy policy that informs users about how information about them is collected and used. And notably, the guidelines do not provide for enforcement and instead just encourage the members to establish enforcement mechanisms independently. The SEAL programs are another prominent form of this self-regulation. What a SEAL program is It requires its participants to abide by codes of information practices and then submit to some variation of monitoring. This is to ensure compliance. Companies that abide by the terms of the SEAL program are then allowed to display the program's privacy seal on their website. So I put some of the examples that are up there, and as you can see, they're all trademarked. There's a Trustee, there's BBB Online, and then there's WebTrust. The Trustee, which was founded in 1997 by CommerceNet's consortium and the Electronic Frontier Foundation. Trustee is a nonprofit organization based in California. It provides a license agreement that governs the licensees to adhere to standards for notice, choice access, and security based on the OPA guidelines. And this program periodically reviews licensees' information practices, as well as provides third-party monitoring of those. The BBB Online is a subsidiary of the Council of Better Business Bureaus, and they started their SEAL program back in 1999. In order for a company to post the BBB Online seal on its website, what it has to do is it has to post a privacy policy that conforms to the program's information practices principles. And they also have to complete a compliance assessment questionnaire, consent to participate in the specific dispute resolution systems, and then they have to submit it to monitoring. And once it's approved, they get the go-ahead to be able to use the logo and get access to the logo to put on their site. The last one I have on here is the WebTrust, and that was created by the American Institution of Certified Public Accountants, or AICPA, as well as the Canadian Institute of Chartered Accountants, which is CICA. What this is it's a SEAL program that licenses qualifying certified public accountants. So the technology-based model for data protection utilizes technological security measures to protect individuals' personal data. While it is commonplace for companies to utilize technology to protect data developments in commercial available hardware and software, all of these have enabled the consumer to establish privacy protections for their own online activity. Consumers may now select from a variety of technological means to ensure, to varying degrees, the privacy and security of their own communications. Several examples illustrate the fundamental elements of the technology-based model. Consumers may utilize digital cash to consummate an e-commerce transaction, such as an online shopping cart function. Encryption is commonly used by both companies as well as individual customers to ensure the privacy of communication between parties. Email senders can utilize anonymous remailers or even proxy servers to try to preserve anonymity and privacy in email communications, such as the I used to use it every once in a while. It's the major domo email relay system that was common in the 1990s. Given the technology-based models, obvious dependence on technology and the array of new technology coming to the market, the security and the trustworthiness of technological systems still remains a pertinent concern. So while a data protection model provides an analytic framework to evaluate the flow of data, key aspects of the model must still be defined. These aspects include the coverage of the protection, the definition of the data to be protected, and the scope of limitations of use of the data. So let's start with protection coverage. In a general sense, a data protection model must define what data is being protected. The nature of the data varies its substance as well as its use, and such variation must be taken into consideration in determining whether a class of data merits protection and to what degree. When we start talking about personal information, not only must a data protection model define what data is protected, but it must also define what constitutes personal information. And it's kind of what I was saying for the HIPAA data that was being protected by that medical device equipment company. So personal information can include name, age, gender, street address, email address, social security number, or national identity number, depending where they are in the world, as well as their telephone number. So this information can exist in many different forms. It could be electronic or hard copy documents, which are probably the main examples I can give you. And they may be managed or stored according to one or more general classifications. The key is to understand the source of personal information, whether it's in public records or publicly available information, or if it's specifically non-public information. So here in the United States, we have a lot of public records, like my transaction that I have when I purchased my house is considered to be public record. So not only does it have my name, but it has my address as well as how much I paid for my house and how much I've been paying annually in taxes. So public records are information collected and maintained by a government entity and made available to the general public. These government entities include the federal, the state, and as well as local governments. And state and local public record laws vary from state to state and municipality to municipality as to their public availability. Many types of public records have important historical uses. For example, the example that I gave you about real estate, well, here, real estate records contain detailed information on parcels of property that not only reveal the ownership, but they reveal the assessed value, the amount paid for the parcel, the taxes imposed on the parcel, as well as any improvements that are made to the home. This information is considered public as a matter of the law, so that each person that owns real estate can determine if the taxes assessed are fair to the other parcels that are available in the area. For publicly available information, what this is information that is generally available without restrictions. Some examples of this include names and addresses in telephone books, as well as information that's in newspapers. And then we get to the all-important non-public information. And this is the information that's not generally available or easily accessed due to law or customs. Examples of this type of data include financial data, medical records, adoption records, a company's customer base, or even employee databases that usually contain what would be considered non-public information. It's important to note that the same data elements may be public record, publicly available, and non-public. The example I'm going to give you is a name and address may be a matter of public record on a real estate deed, publicly available in a telephone book, and included in non-public databases such as healthcare patient files. But to understand how to handle the data and the name and address, you have to understand the source that provided it. So let's talk about a little bit about the scope and limitations of use. Inherent to the data protection model are appropriate limitations and considerations of the scope of the rules the model sets forth. Particular types of data may be outside the scope of a given model if the rules do not sufficiently protect it. The scope of protection may vary from these different types of data. Let me give you a listing. So the first thing I'm going to talk about is secret, private, or sensitive data. So these would include government filings, consent requirements, national identifiers, criminal records, health data, or associate or like union memberships that you're in. All of these are considered, secret, private, and definitely are sensitive data. The next I have on the list is consumer data, which we're all familiar with. Data collected online, so privacy around what information can be collected or what becomes required fields. And the last one is aggregate or anonymous data. When we talk about notice is a description of an organization's information management practices. And the typical notice will inform an individual what data are being collected, how that data is being used, whether the data are being disclosed or transferred to third parties, and if so, to whom, how to exercise any choices that may exist with respect to use, disclosure, and onward transfer, and whether or not the individual can access or update, the information that's given. Notices can serve two important purposes. One, they can be consumer education, and two, they could be corporate accountability. So they can provide individuals with the information they need to understand how a company will process information, and they also provide regulators with a benchmark against which actual corporation practice is being judged. When I use the word access is the availability of an individual to view personal information held by the organization and may be complemented by the ability to update and correct the information. Companies may not always offer this access. For example, personal information may be very difficult or costly to retrieve, so access may not be appropriate. In general, if information is used for substantive decision making within the organization, it becomes appropriate to offer access so that individuals can ensure that their information is correct and complete. And the last one I have is choice. Choice is the ability to specify whether personal information will be collected and or how it will be used and shared. Choice is generally appropriate when information is used for marketing communication. Choice is often not appropriate in many other situations. So for example, it would not make sense to offer choice about, sharing a person's name and address with a shipping company that is delivering an order, right? Similarly, companies will not offer choice about the use of information for debt collection or even legal compliance. So where choice is appropriate, it should be offered in a meaningful manner, along with the notice that informs the individual about the processing. And it also needs to provide the option to opt out or opting in for the action itself. So let's talk a little bit about what opt-in and opt-out are. Opt-in basically means that an individual is able to make an affirmation indicating a choice. So the example I have here is an individual checks a box stating that she wants to share her information with the third parties. Opting out means that an individual's failure to object to use or disclosure implies that a choice has been made. The example I have is unless an individual checks or unchecks a box, her information will be shared with third parties. Underlying the views of privacy and the models for protecting data are certain fundamental privacy principles. These principles are foundational concepts that need to be considered in formulating any data protection regime. The Code of Fair Information Practices, also known as the Code of Fair Information Practices, was first developed in the early 1970s by the U.S. Department of Health, Education, and Welfare. Today, they're known as the Department of Health and Human Services. Advisory Committee on Automated Systems is the group that is under the Department of Health and Human Services. And this code has become the backbone for most recent variations, for which have the following core elements, and there are 7 of them. The first one, as you can see on the screen, is openness. This is the existence of record-keeping systems, as well as data banks that contain personal data that must be publicly known, along with a description of the main purpose, as well as, why I'm using the data. Number 2 is individual participation. Individuals should have the right to view all of the information that is collected about them. They must also be able to correct or remove data that is not timely, accurately relevant, or complete. Number 3 is collection limitation. There should be limits on the collection of personal data. Data needs to be collected by lawful and fair means and should be collected where appropriate with the knowledge or the consent of the subject, meaning that you have to have a two-way mechanism in there to be able to pull in specific information. 4 is data quality. Personal data should be relevant to the purposes for which they are collected and used. Personal data should be accurate, complete, and timely. 5 is finality. And finality means that you have to put limits to the use and disclosure of the personal data. Data should be used only for purposes specified. When you actually start collection of the data or the time of collection, you really need to go through and really set a time frame limit to when the data is going to expire. And data should not be otherwise disclosed without the consent of the data subject or, what legal authority is out there. 6 is security. Personal data should be protected by reasonable security safeguards against such risks as loss, unauthorized access, destruction, use, modification, or any kind of disclosure. This is where breach laws come into place with it. And then number 7 is accountability. And record keepers should be accountable for complying with all of the fair information practices that are out there. So back in 1981, the Organization for Economic Cooperation and Development, we see it abbreviated here in the States as OECD, What they are is they're a 23-nation body that includes the United States and Japan, in addition to several European nations. What they did was they published a set of privacy principles entitled the Guidelines Governing the Protection of Privacy and Transborder Data Flows of Personal Data, known more informally as the OECD guidelines. What these principles were subsequently endorsed by the U.S. Federal Trade Commission, and they've served as perhaps the most widely adopted of the frameworks for fair information practices. The OECD guidelines enunciated 8 privacy principles, and the importance of these has been further reinforced by the FTC. You'll see I have the 8 listed on the slide deck. Let's start with the collection limitation principle. So there should be limits to the collection of personal data, and any such data should be obtained by lawful and fair means, and where appropriate with the knowledge or consent of the data subject. So as you can see, a lot of these start looking like the same thing, it just worded or phrased just a little bit different. The second that we have is the data quality principle. This is where personal data should be relevant to the purposes for which they're being used and to the extent necessary for those purposes. So that should be accurate, complete, and kept up to date. 3 is the purpose specification principle. The purposes for which the personal data are collected should be specified not later than at the time data collection and the subsequent use limited to the fulfillment of those purposes or such others as they're not incompatible with those purposes and as specified on each occasion of the change of purpose of that data. Number 4, we have the use limitation principle. Personal data should not be disclosed, made available, or otherwise used for purposes other than those specified in accordance with paragraph 8, except, and they have this broken down into 2 sections. It's with the consent of the data subject or by the authority of the law. For 5, we have the security safeguards principle. This is where personal data should be protected by reasonable security safeguards against such risks as loss or unauthorized access, destruction, use, modification, or disclosure of data. Number 6 is the openness principle. There should be a general policy of openness about developments, practices, and policies with respect to personal data. Means should be readily available of establishing the existence and nature of the personal data and the main purposes of their use. So as well as the identity and the usual residence of the data controller. Number 7 is the individual participation principle. Here, an individual should have the right to to obtain from the data controller or otherwise confirmation of whether or not the data controller has data relating to him, or B, to have the data relating to him communicated to him within a reasonable, timely, charge. So if any that is not excessive in a reasonable manner and in a form where it's readily intelligent to them. The third thing we have on here is to be given reasons if a request is made under subparagraph A and B, which we just discussed, and that is to be able to challenge such denial. And the last one, D, is to challenge data relating to him, and if challenge is successful, to have the data erased, rectify, completed, or amended. And the last principle that I have on here is the accountability principle, and that's where the data controller should be accountable for complying with measures which give effect to the principles that we have just covered. So I am going to give you an option. I usually have a 5-minute break here. Do we want to take a 5-minute break and take a look at it, or do you want me to continue on, and that way you'll get on with your day earlier?
No, just continue. It's fine.
Okay, we will continue then. Let me take a drink of water real quick. All right. So I guess the question is can you have privacy without security? I think we talked about this a little bit.
Absolutely not.
Yeah, I feel exactly the same way, and you know, I don't even think there's anything to challenge that idea.
Yeah, the more privacy you want, the more security you would need.
Yep. If you have some time afterwards, this URL, which is staysafeonline.org, it's a really good website. They talk a lot about being able to have privacy without security. So you can have security without privacy, but you can't have privacy without security. Privacy includes the laws, the regulations requiring companies to protect your data, and security is the technical method used to protect that data. Privacy laws are shifting globally in a big way, and this evolution is keeping privacy professionals on their toes. So with the increased complexity and compliance with global privacy requirements, the adequate security is one constant that we're seeing. And the simplest way to ensure that companies are both complying with law and protecting their customer and employees' most important information. Security and transparency are privacy's key driver of success. Above and beyond the laws governing privacy, companies are obligated to ensure that they have the proper administrative, technical, as well as physical security safeguards in place, and to protect that personal information that's out there. So by affirming adequate security measures and providing transparency about security protocols, companies can help their customers feel more comfortable and more confident about their decisions they're making regarding the information they choose to share. A recent study by the Office of the Australian Information Commissioner, or the OAIC, revealed that 71% of the Internet of Things devices and services used by Australians failed to adequately explain how personal information was collected, used, and disclosed. Companies that hold and manage critical information must gain and continually earn the customer's trust through transparency. Why else would we risk handling our most personal and high value details without, being able to be transparent? There's really no one size fits all in privacy and security. Security and privacy must be implemented across all thresholds, and there's no one size fits all security and privacy answer. A smart security solution should therefore employ preventative, defensive, as well as reactive solutions. It has to be strategic. I like to say that you really want to be innovative and smart about, deploying your security solutions around privacy. And today's strongest security leaders will partner with key stakeholders, to stay at the forefront of cybersecurity trends and leverage this knowledge to constantly innovate and implement creative solutions. We are only as secure as our weakest link. In our connected world, data protection is the key to a prosperous future, but we are only as secure as the weakest link in the chain. And the most common privacy weaknesses are often human error and technical shortcomings. So the example I can give you here is that data from the ISTR shows spear phishing campaigns targeting employees increased 55% back in 2015, and fake technical support scams have evolved from cold calling unsuspecting victims to attackers fooling victims into calling them directly now. Let's talk a little bit about GDPR, CCPA, and CPRA. When we look at the EU GDPR, it was created, several consumer rights. As you can see on here, we've got the right to access, the right to be forgotten, the right to consent. These consequences are for non-compliance significant, and the fines that we see up here are up to 20 million euro for 4% of what the global revenue of what the company has. For the CCPA, it's the California Consumer Privacy Act. What it does is it creates new obligations for covered businesses, and it was modeled a lot against the GDPR information that's out there. You'll see in it that consumers' rights related to the control of their own personal information, which is the key aspect to most of the privacy that's out there. This took effect back in January 2020, and it has been amended several times by the state of California's Attorney General. When we look at the CPRA, it's an addendum to the CCPA, and what it does is it goes that next level by creating additional consumer rights, modifying the CCPA rights, mandating new categories of consumer personal information with associated rules, and then it establishes the privacy agency that's out there. And just, I don't know if you're going to ever find it useful, but if you have customers that are back in the United States, I did put the URL in for the MINTS matrix on here. And what that gives you is the availability to look at not only California Privacy Rights Acts, but you can look at the state of Florida, you can look at the state of Illinois. It doesn't matter. They actually go into a lot of detail and make sure they keep their website information up to date with the latest privacy information that the state legislation has. All right. So let's start taking a look at the steps that we have for information management. So both risk management and good corporate citizenship require that organizations develop policies for the appropriate collection and use of personal information. Depending on the organization's business, these policies may include such things as maintaining opt-out lists for direct marketing, developing appropriate security for customer financial or medical records, executing proper contracts to authorize international data flows, or even publishing an online privacy notice if the data is collected over the internet itself. Corporate policy leaders must assign their organizations in thinking about privacy policy development, and it's easiest to do it in a formal, objective way, meeting policy goals as well as preserving business flexibility. Privacy privacy executives must also understand and anticipate further future changes, both in the regulatory environment and in companies' business needs. To achieve these objectives, companies need to consider four distinct tasks. So that's where we have this discover, build, communicate, and evolve. So it ends up being kind of a framework or a foundation that we work off of. Let's start with one, which is discover. So before you begin to draft a privacy policy, you have to first consider the company's informational goals and corporate culture. What these laws regulate is the company's collection or use of information. So does the company want to be able to use the information as aggressively as possible? You have to ask, does the company want to limit the use of the information to try to achieve a competitive advantage as a privacy sensitive leader? Or does the company's executive management or shareholders have privacy issues that need to be considered? You also want to look at how do the company's information policy objectives mesh with those of its competitors, their customers, as well as their business partners. And to answer these questions, you can begin to help your organization define, what its core information goals are. These goals serve as the foundation upon which the company's policies are built. In addition to the myriad of state, federal, and international laws that regulate the collection, use and disclosure of personal information, many industry groups have promulgated self-regulating guidelines, some of which are mandatory for our members of the specific industry groups. The example I have here is the Direct Marketing Association, or DMA, requires its members to comply with the provisions of DMA's privacy promise. In the world of e-commerce, the FTC, or Federal Trade Commission, has been actively and aggressively pursuing companies that post privacy policies and then do not comply with their posted policy. The FTC initiates these actions under Section 5 of the Federal Trade Commission Act, which prohibits unfair and deceptive trade practices. Similarly, several of the state attorneys generals have initiated enforcement activities against companies that breach promises made to consumers in privacy policies. Accordingly, it is essential that, to the extent you advise your company on privacy policies, you make it clear to your management team that failure to comply with your posted privacy policies is a deceptive trade practice, and it's actionable by our Federal Trade Commission, as well as other state and federal authorities that are out there. In order to provide useful advice to your organization regarding privacy, it's essential that you understand all of the company's actual practices with regard to personal data, as well as what its goals are with respect to the use of the personal data that it has collected. The success of this exercise hinges on asking the right people the right questions, and the successful privacy professional forges honest and open relationships with the individuals in all the departments at all levels. The example I'll give you here is the privacy professional should have regular dialogue with the individuals responsible for legal compliance, customer service, marketing, as well as sales, to determine if the company's current practices and their future goals are really being clearly understood. The leader should also communicate regularly with the individuals who implement the policies and procedures to help ensure that the policies are properly adopted and that policies address all the questions the company personnel face. Number 2 that I have on here is build. So once you understand your company's current practices and goals, you can help your company find the best way to address consumer expectations while meeting the business goals. And by undertaking a formal balancing exercise, a company can realize that it's you want to be able to realize its information policy objectives, but you also want to go back to the actual company policies that you have documented for that information. It's hard sometimes because you want to maintain flexibility within the organization for use and distribution of data. You don't want to, for example, you don't want to make it so difficult for them to actually get access to the data that it harms their job or makes their job function delayed or incapable of doing whatever they need to do. But you also want to make sure that the use and distribution, the data needs to be, reasonable, where it's as needed for the company to achieve their short and long-term business goals. Here in the state of Florida, we actually have privacy laws, and this comes from the state of Florida, that says that even if you have access to file shares that are out there, you aren't really allowed by law to be able to just peruse all of the folders that are in there. You should only be keeping the information that is required for you to do your job. It's not meant there so that you can browse it or so that you can go out there and collect even more information to be able to do anything. What you really want to be able to do with it is just go out there and use the data as you normally need to use the data in performing your job. But let's say there's a legal case out there, or even more worrisome would be like mergers and acquisition data out there. You don't want people to just feel free to start perusing these directories and then finding out information that you don't want disseminated out there. Best practices is to take that sensitive information and put it on a different file share and lock it down with credentials. But you still need some kind of employee trust with any of this information. And if here in the States, like I said, if you find that you aren't trusting your employee and you're actually auditing what files they are accessing, and you find that they're accessing files that they really shouldn't be doing, that really becomes a legal activity here in the States. Additionally, by considering all of the issues related to the data collected and used by the company will be well positioned to leverage its progress to build consumer and business partner trust. For 3, which is communication, that's usually going to be your typical communication that's out there. So most companies already have a chain of command where they actually have to report all the information across. Obviously, your information security policies, as well as their procedures, are going to be that documentation, and then any awareness campaigns that you have for the privacy and protection of data kind of fit underneath this communication globe. And then the last one that we have is evolve. And basically that goes back to the same thing that we would normally talk about, where you really want to make sure that you're learning from any mistakes that you have or anything that you might not feel comfortable with. For example, your experience speaking with privacy to a customer of yours, might lead you to needing to either reframe, rephrase, or better contain that information from a privacy perspective so that you can have better conversations with the rest of your customers. And, the ability to audit and make sure that you have the right security protections for those.